A sudden impact, a sickening crunch against polished metal. What began as a child's simple mishap inside a bustling car dealership quickly spiraled far beyond a minor repair. This wasn't just a dent. It was the start of a bewildering legal maze, tangled in deception, conflicting claims, and a $1,500 bill. That invoice, seemingly straightforward, hid a much darker truth. For one family, this bill became a ticking clock, threatening a financial drain and legal trouble. Was it an honest cost or a calculated maneuver? Today, we unravel how that seemingly small dent exposed a potential fraud. We reveal the critical distinction between genuine responsibility and deliberate manipulation, examining the surprising secrets an ordinary invoice can truly hold. Could a piece of paper reveal a crime? Our story begins in a new car dealership in sunny Arizona. The air hummed with possibility. A father, his girlfriend, and their sons wandered the showroom, drawn by the shimmer of fresh paint and the promise of new adventures. The scent of leather hung heavy, a luxurious prelude to a purchase. Then a playful moment. His 13-year-old son, a towering kid at almost 6 feet and 200 pounds, tried a daring feat, a simultaneous piggyback ride for his younger brother and his girlfriend's son. A flash of exuberance, a sudden stumble, a sickening thud. The boy's head collided with the fender of a brand-new $50,000 sedan. He was shaken, his pride bruised, but physically unharmed. The car, however, bore a distinct rippling dent, a stark imperfection on its gleaming surface. The moment's joy evaporated. The father knew. Surveillance cameras silently recorded. His girlfriend's identifiable license plate was clearly visible in the parking lot. He acted with integrity. He immediately sought out the dealership manager, reporting the damage, taking full responsibility. He asked about the dealership's insurance, expecting a simple process. The manager, however, gave a flat, immediate denial. No insurance, he claimed, for such incidents. The father's assumption of a straightforward solution began to unravel. Days turned into a week. Then an envelope arrived. Inside, a bill for $1,500 demanding payment for the auto body repair. But a crucial detail jumped out. Plainly printed, undeniable, were the words, "Paid by insurance." This was no simple mistake. The manager had explicitly stated no insurance. Yet the repair invoice claimed otherwise. A profound contradiction emerged. The father now faced a chilling dilemma. If he paid the dealership, he risked being double-dipped, paying the bill now only for the dealership's insurance company to pursue him later. He could be on the hook twice. Refuse payment? That meant battling a business that had already shown a willingness to deceive. A ticking clock started. The father held the invoice, its stark words a direct challenge to the manager's lie. What was the truth, and how could he protect his family from potential fraud? A simple dent. A $1,500 bill. But one line on that bill would transform a straightforward accident into a high-stakes legal and ethical battle. Today, we unravel a complex case, where a father's integrity collided with a dealership's dubious demands, revealing layers of potential fraud and the intricate world of insurance law. This is a story about seeking truth when the facts become obscured. Our story begins with a father grappling with the immediate aftermath of his son's accidental damage to a brand new car at a dealership. The initial demand for $1,500 seemed clear. He was prepared to accept responsibility. But then a piece of paper arrived, the repair bill. It stated explicitly that the $1,500 repair had already been paid by insurance. This single detail shattered the narrative. The father, armed with this contradictory bill, began to question everything. Why would the manager lie, insisting the dealership had no insurance for such incidents? If insurance had already paid, wouldn't the insurance company, not the dealership, be the one pursuing him for reimbursement? These fundamental questions formed the bedrock of a rapidly complex investigation. The dealership's demand for $1,500 remained firm. Yet the father felt an unsettling sense of unease. He knew something was fundamentally wrong. As our inquiry into this perplexing situation deepened, we consulted various sources. Online legal communities provided a flurry of initial reactions. Industry experts offered their perspectives. Several competing theories quickly began to emerge. One common argument suggested the $1,500 was simply the dealership's deductible. Many commercial insurance policies, especially for high-value inventory like new cars, carry substantial deductibles. These can often be $5,000, $10,000, or even significantly more. Could the dealership simply be attempting to recover their out-of-pocket cost, a standard practice in many claim scenarios? It seemed a plausible explanation. The dealership had incurred a cost, and perhaps the father was being asked to cover the portion not met by the insurer. But if this was merely a deductible, why did the repair bill explicitly state, in no uncertain terms, paid by insurance? The language on the document directly contradicted this seemingly straightforward theory. The discrepancy was glaring. Another theory emerged from our consultations with auto body repair specialists. Some experts pointed out that auto body estimating software often includes a line item for insurance pay. This designation, they explained, is used to differentiate the insurer's portion of a repair from any customer-owed deductible. It doesn't necessarily mean the insurer has already paid out the claim. It could simply be an accounting designation within an estimate, a placeholder for the expected insurance contribution. This explanation offered a plausible, even innocent interpretation of the bill's wording. It presented a path where the dealership might not be acting nefariously. The father considered this. He hoped for this simpler answer. However, a crucial piece of decisive evidence, provided by the father himself, quickly and unequivocally dismantled this theory. The father revealed a critical detail he had overlooked in his initial confusion. The repair bill not only stated paid by insurance, but it also included a distinct, unmistakable claim number. Even more telling, it explicitly named lot damage insurance as the payer. This wasn't an estimate or a projected figure. This was an invoice for work already completed and paid for by a specific insurance entity. This specific detail transformed the entire situation. With an official claim number and lot damage insurance explicitly listed as the payer on the invoice, both the deductible defense and the misinterpretation theories crumbled entirely. This new information strongly indicated that the dealership's insurer had already compensated them for the damage to the vehicle. If the dealership then proceeded to collect $1,500 directly from the father for the same repair, it would constitute attempted insurance fraud, a felony offense in many jurisdictions. The stakes had just escalated dramatically. Did you know that instances of insurance fraud can cost consumers billions of dollars annually through increased premiums? It's a crime with widespread, subtle consequences. This revelation brought us to the legal principle of subrogation. When an insurance company pays out a claim to its insured party, in this case the dealership, they often step into the shoes of that insured party. They gain the right to pursue the liable party, which was the father, to recoup their losses. This is standard procedure. However, if the dealership had already been paid by their insurer for the damage, then any future collection efforts against the father should come directly from the insurance company, not the dealership. The dealership, having been made whole by its insurer, would have no further legitimate claim against the father. We briefly explored other potential complications. Could the father's homeowner's insurance policy potentially cover such damage? Would there be a diminished value claim, as a newly repaired car might be worth less on the market, even with minor bodywork? These considerations, while valid in other circumstances, became secondary to the primary issue of the dealership's highly questionable conduct. The father now faced not just the straightforward liability for his son's accident. He was caught in the morally murky waters of a potential fraud scheme. He had to choose between paying a potentially fraudulent bill directly to the dealership or waiting for a legitimate claim from an insurance company that might never come. All the while, he was trying to teach his children about integrity and responsibility. The ticking clock of potential legal action from either the dealership or the insurance company weighed heavily upon him. Imagine staring at an official document. Every line on it seems clear, precise, and unambiguous. Yet you feel utterly trapped by the conflicting stories it represents, each detail pulling you further into uncertainty. Understanding these complex legal and ethical dynamics, the father knew his next move had to be strategic. He needed to confirm his precise legal standing before taking any action. He sought advice that could definitively navigate this ethical and legal quagmire. The path forward was less about if he was liable and more about who he was liable to and for what legitimate amount. The fight for clarity had just begun. One document, a single repair bill, held the truth, arriving with an innocent appearance yet carrying explosive implications. This wasn't just a cost estimate, it was a record of payment. Inside its lines lay a claim number, a specific detail, lot damage insurance, paid. The very insurer for the dealership had already settled the repair cost. This was irrefutable evidence. It was proof of a transaction that should have closed the book on the incident. The father, holding this critical document, knew he couldn't proceed alone. He tapped into a workplace benefit, a free legal consultation. The stakes were high. Was he about to be defrauded? Could he, in turn, become complicit? Then came the verdict, clear, unambiguous. The legal expert's advice echoed like a bell. Do not pay the dealership. This instruction wasn't a suggestion, it was a firm directive. The pivotal moment in his ordeal, the turning point. The manager had lied. Their demand for $1,500 after their own insurance had already covered the cost was unequivocally an attempt at insurance fraud, a direct, deliberate double dip. The father was facing an attempted exploitation. His obligation was shifting. The legal expert explained, if any party were to legitimately pursue him for damages, it would be the dealership's insurance company. They would do so through a process called subrogation, not the dealership itself. This distinction was critical. By refusing to pay the dealership, the father wasn't evading responsibility. He was protecting himself from complicity in a fraudulent act. He was preventing a potential double payment that could still come back to haunt him. He was refusing to be manipulated. While the ultimate repercussions for the dealership remain unseen, this discovery put them in a legally precarious position. An insurance company, once aware their client attempted to collect twice for the same incident, would be very interested. Such actions carry significant consequences. The father's initial act of integrity, reporting the damage, was ultimately upheld, not by blindly paying an unjust bill, but by exercising diligence, by seeking informed legal counsel. He successfully navigated a complex, ethically fraught situation. He demonstrated to his sons that true accountability involves not just owning up to mistakes, but also recognizing and resisting attempts at exploitation. A powerful lesson in discerning justice. Why did the dealership lie? The initial call seemed straightforward. Report a dent, accept responsibility. But the manager's response was not just misleading, it was a deliberate deception. This isn't merely about one car. It exposes a predatory tactic some businesses attempt. Today, we unravel how a single document exposed an entire scheme and how you can protect yourself. Dealerships, despite robust lot damage insurance, face a calculated choice. File a claim, risking a subtle premium increase later, or try to collect directly from you, securing an unwarranted additional payment. This case perfectly illustrates that second, unethical path. The manager's initial false claim that they had no insurance at all was a clear setup. It aimed to pave the way for a double dip. But their plan contained a critical flaw. The repair bill itself arrived. On it, an explicit paid by insurance notation, complete with a claim number. This precise detail became the undoing of their scheme. Without it, the father's situation would have been far more ambiguous, far more difficult to resolve. What happened next for the father? His immediate financial responsibility shifted dramatically. He no longer needed to pay the dealership. Instead, he prepared for potential contact from a very different entity, the insurance company. Any legitimate claim for reimbursement would now originate directly from them, not the business. This changes everything. He now possessed potent leverage. He could choose to inform the insurer about the dealership's attempted fraud. That single action could unleash significant legal and financial consequences for the business. For the dealership, a ticking clock began. This incident offers crucial lessons for anyone caught in a similar bind. First, document everything. Names, dates, conversations, especially every piece of paperwork. Second, never assume initial liability means accepting an unreasonable or potentially fraudulent bill. Third, if any bill seems contradictory, question it immediately. Fourth, always consult your own insurance agent. Seek legal advice, even through free consultations, before making significant payments. Understanding commercial policies, deductibles, and subrogation is your strongest defense against those who might seek to profit from your misfortune.